So how do you handle your property if you want to transition it to other beneficiaries at your passing, but your state does not have a transfer on death deed? Let's talk about this. I'm Valerie Zammitti of Zammitti Law. We are an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you're seeking assistance in either estate planning or probate trust administration in New York or New Jersey, you can reach out to us for free consultation at yourplanningattorney.com. And speaking of value, we are also always here to educate folks for free. So please ask your questions and share so together we can help some folks along the way. This specific question was with regard to New Jersey that as of today, I believe, does not have a transfer on death deed option. And I think there are 12 states in total. New York just happened to add it recently. Now, a transfer on death deed, as you can imagine, like a bank account where they say transfer on death, is simply just designating a beneficiary who will then receive that asset outside of the probate process. Now, I will reiterate something I've said multiple times in the past. There are some risks and challenges with creating a transfer on death deed as opposed to other options. So just because they're available in many of the states does not mean that is the best plan for you and your family. Now, New Jersey doesn't offer the transfer on death deed. So what can you do instead? Well, this is where we would strongly suggest you consider a living trust, okay, a revocable living trust. And that it's essentially just you in a different title. And a trust is a contract. And when it's a revocable living trust, it's you establishing that contract with yourself. Because that asset remains in your control, all the same usage, all the same property taxes, requirements to upkeep it, maintain it, etc. So this living trust, though, because it's under a contract, it's essentially deemed it's a separate entity from you as an individual. And as such, it avoids the probate process, just like a transfer on death deed. But the key with using a trust is you can build in more protections for different scenarios, not only for yourself, but then later for your family. And it really is a much easier method in transitioning and a more protected method to get it to your beneficiaries. And if your adult children are the only heirs and you want to avoid probate delays, this is really, again, the most streamlined solution. It's especially helpful, if you want to plan ahead of incapacity, right, for future management of the property. That person, they can automatically step in and take care of the financials with regard to the house, etc. So again, a trust is a common effective solution in New Jersey. We use it all the time. And with the trust, which is the contract, again, you establish with yourself, a professionals that's guiding you will typically also transfer the ownership of your deed into the trust for you, right? This is the funding process where you have to retitle certain accounts or other assets to the title of the trust. And your home would be one of them. So that would be preparing a deed and having that recorded to reflect the trust now as the owner. This is something we do routinely in our practice. So we hope you've learned something new here today. And again, I'm Valerie Zammitti of Zammitti Law. We're an estate planning firm in New York and New Jersey. And if you need assistance in our neck of the woods, feel free to reach out and set up a consultation at yourplanningattorney.com. Please don't forget, share, and take care.